the court regime then probably could not give him that leeway to argue his case. But today we'll be listening to see how both sides argue their cases before the judges and wait their ruling, probably either tomorrow or on notice as it will be for the case of Okia Omutata. Betty?
All right, Patrick Amimo there reporting from the Milimani Law Courts, just bringing us up to speed with the cases that are still pending in court and that ruling that we're waiting for with regard to David Kosing's petition. So we'll take a short commercial break, but we're coming back to continue the conversation. I'm seeing quite a number of tweets with regard to the discussion we've been having here. Thank you very much for them. Keep them coming. I'll sample them before we wrap up the show. All right, so if we take a break, we'll be back in a few minutes.
This is KTN News.
Simply put, is a digital acceptance channel by which consumers can pay either their friends or family, or they can pay merchants directly from their bank account by using their mobile banking application provided to them by their bank. They can pay a merchant by either scanning a static QR code and then entering the purchase amount, or by scanning a dynamic QR code which is unique to that purchase and already has the purchase amount information along with the merchant information. If the consumer does not have a smartphone and they have a feature phone, they can still use the service by using the USSD shortcode functionality. Whether the consumer is paying or sending money to their friends or family or paying a merchant, the service is free to the consumer.
This is KTN News.
All right, welcome back to News Center. Thank you very much for staying with us. We're following on quite a number of top stories here on the show, but we also have a discussion that has been ongoing here in studio. I'd like to continue with it. And Mambola, I didn't hear your thoughts about, petition. He says that, he hopes. All right, welcome back to News Center. Thank you very much for staying with us. We're following on quite a number of top stories here on the show, but we also have a discussion that has been ongoing here in studio. I'd like to continue with it. And Mambola, I didn't hear your thoughts about, petition. He says that, All right, welcome back to News Center. Thank you very much for staying with us. We're following quite a number of top stories
for the judges, because that would be what lawyers call subjudice
here on the show. But we also have a discussion that has been ongoing here in studio. I'd like to continue with it. And Mambola, I didn't hear your thoughts about petition. All right, welcome back to News Center. Thank you very much for staying with us. We're following quite a number of top stories
for the judges, because that would be what lawyers call subjudice
here on the show. But we also have a discussion that has been ongoing here in studio. I'd like to continue with it. And Mambola, I didn't hear your thoughts about petition. All right, welcome back to News Center. Thank you very much for staying with us. We're following quite a number of top stories
for the judges, because that would be what lawyers call subjudice
here on the show. But we also have a discussion that has been ongoing here in studio.
Treat it like it was not there.
All right, welcome back
to not
News Center. Thank you very much for staying with us. We're following quite a number of
feel Form 24A or whatever other form. Raila Odinga has been out there giving extremely well thought, clear ideas on how he wants this election to go, and one of them has been, no, I am not participating in this election. So the IEBC should settle that question. But we have also seen a problem with the interpretation of some of these legal questions, even from the IEBC itself. Look, for instance, under the 2013 presidential election petition, the Supreme Court pronounced itself in what lawyers like to call obiter dicta, that, you know, the people who are, or the candidates who are eligible for a fresh presidential poll are the president-elect, number two, if he is the one who contested the election, and any other candidate who contested the election. The other candidates in that election who chose to accept the results are treated as having accepted the result or acquiesced to that result, and therefore they should not be on the ballot. But we have seen a chairman, together with his commission, who come and tell us that, you know, the only two people who are going to be on this repeat presidential election are going to be Raila Odinga and Uhuru Kenyatta, which was legally wrong, and which we didn't expect from a commission of the stature that Mr. Chairman Chebukati is leading. And then the parties go to the Supreme Court, and the Supreme Court says, hey, go to the High Court, because the High Court is the place where is the home of constitutional interpretation. Go there and get a proper understanding of really who should be in this particular ballot. And the High Court says, hey, every person who is entitled to participate is entitled to participate, except that, you know, the time we have will not allow us to go into fresh nominations. So you guys go and get everybody who was in the ballot to be on the ballot. However, that does not even mean that you're participating. Your name could be on the ballot. That is what the court said. But it doesn't mean you're participating. All you need to tell your people is, hey, you might see my name there. In any event, you will not see it, because, you know, if you're a NASA supporter and you have been persuaded that you should not vote, then it means you're not getting into the polling station, which means you will not even see his name.
If I may just weigh in, election management is not based on rumors and guesswork. So I believe IEBC's spectacular fail into the limited issue of management of candidates is well documented. They started very well, but they've been flip-flopping and listening to political voices instead of relaxing, reflecting, and observing what the law says and acting with clarity. Remember, in terms of election management, the centrality of clarity is an indispensable component. On 1st of September, Betty, the Supreme Court annulled the presidential election. On 5th of September, IEBC, guided by the Supreme Court 2013 judgment, and I think that was well placed, because insofar as Article 140, Sub-Article 3 says the fresh election may be conducted in 60 days, we don't have supporting laws or regulations that can deal with processual issues up to the date of that ballot. Now, what that means is that Parliament, for one, is not allowed to make those laws in the middle of, during this intervening period, but we could use judicial interpretation to provide clarity where there's confusion or controversy. Now, IEBC itself began by relying on that clarity, part of the clarity in the 2013 judgment, when the Supreme Court was building scenarios. They said, where there's only one candidate who petitioned, you know, the Supreme Court to challenge the election of the president-elect, that is the person to go back to the election.
Beautiful, confident Susie goes to visit her friend Carol. The two women share quite a lot in common. Though Susie is not sure, maybe Carol, like her, is a fly.
Then show me the other law, because there is no any other law in statute or regulation except the interpretation of the Supreme Court on what it means to conduct a fresh election and who is entitled to participate.
Right.
So on that limited question, I said, I also participated in this presidential election petition, although not as a petitioner, but as an interested party. Lawyers know that if you participate in a petition as an interested party, you must demarcate. You must state and tell us who do you support. Are you supporting the petition, in which case you're supporting Raila Odinga,
yes,
or you're supporting the respondent, in which case you are attacking the petition, in which case, if the judgment is made, you're not entitled to benefit from it because what Mambola is saying, you acquiesce to that election result. Ekuru was on the side of Raila, and he had a good case, and the court told him, this is now a question of interpretation. In our understanding of the hierarchical order, in terms of interpretation of the Constitution, go back to the High Court, interpret with finality. And if you look at the order, the ruling by Judge Maraga, transmitting the question to Judge Mativo, it was very clear that the High Court has the original jurisdiction under Article 165, sub-Article 3, to interpret the Constitution definitively. But if you're not happy, then you can escalate it in terms of appeal until it reaches the Supreme Court.
Yeah.
The High Court, in its own understanding, explained what fresh election means. And it said, in our understanding, it is that all the 8 candidates, it's open to them, should they want to contest, to be included. Now, what IBC started going by making mistakes, IBC should have invited all the 8 candidates, requested them to communicate whether they want to participate or not. Raila had already said he had withdrawn. There is no legal justification for including Raila in a fresh presidential election when he has withdrawn.
Yeah.
Jirongo was
but they said that he did not do that officially.
No. You see, because already under Article 140, people who are saying that Raila has not withdrawn formally, he didn't sign Form 24A. Those are people who the argument is not founded in law. If the justification for Form 24A, if you look at it, that is Regulation 52 of Election General Regulation of 2012 as amended, says, in fact, that regulation opens in these words: withdrawal of candidature after nomination before the general election. Clearly, Betty, that specific provision was intended to apply to persons withdrawing or candidates withdrawing before they progress to the general election.
Okay.
After someone has gone through the general election, the Supreme Court has ordered a fresh election. Surely that state needed fresh laws, regulations, procedures, which for now we don't have. Because we don't have, you're not allowed to extrapolate a provision under Regulation 52 and say, fill Form 24A.
Right.
That form, I believe, the communication by Raila, a written notification. In fact, the language used by the Supreme Court was that if a candidate abandons, the Supreme Court did not say if a candidate withdraws formally. The fact that the Supreme Court said if a candidate abandons an election, then you go to fresh nomination. To that limited extent, Raila had withdrawn. But what is also not open to Raila, and NASA must tell us openly, when the High Court interprets the Constitution definitively and says fresh election means all the 8 candidates, you can no longer rely on the 2013 judgment and say fault the High Court in terms of saying everybody should be included. If you want to fault Judge Mativo in a Ekuru case, you fault it by filing an appeal. They have not filed an appeal. Even if an appeal was filed, that appeal has not been determined. So, but I'm just narrowing what IBC ought to have done on the missteps. IBC ought to have invited all the candidates and say, hey,
who
we
wants
have
to
the
be on the
Mativo
ballot?
judgment. Do you want to participate?
Yeah.
Raila says, I don't want to participate for reasons stated or not stated. Jirongo is not open to him to say whether he wants to participate or not, because at that time he was a judge bankrupt. What IBC ought to have done in law, since Kenya is a multi-party democracy, it was open to IBC to give the United Federal Party, Jirongo's party, an opportunity to replace that candidate, because it's not their fault that the candidate has been a judge bankrupt. The other persons had already declared that they wanted to participate. The question of printing ballot papers with Raila's name there, I think it's a question that if it were to be taken in court, that ballot paper would be found to be illegal. Justice Ringara, if you allow, briefly. Justice Ringara once said...
Let me bring in Mambola to hear what he has to say.
I just wanted to finalize just in less than 10 seconds. Justice Ringara once said, in the Njoya case, when the question of interpreting Section 47 of amending the Constitution, he said that there are so many things that happen out there, outside the court, which fortunately or unfortunately have not been tested in court. Had they been tested in court, much of them would have been struck as illegal or unconstitutional. I see the printing of ballot papers with Raila's name in it as one of that illegality that will go unchallenged because nobody has taken it to court.
All right.
Betty, that is the fickleness of this democracy, that it gives a lot of things on the one side and sometimes it could take on the other hand. You see, the framers of the Constitution are, or might not have been angels. They probably wouldn't anticipate every possible scenario that would arise in the process of a democracy like Kenya growing. And we must understand, for instance, that when all the chips are down, probably somewhere, the true spirit of the interpretation of this Constitution is going to come out. There is this 2013 decision, that Supreme Court decision that we keep relying on. First and foremost, from where I sit, I think that obiter dicta on who should participate in the fresh poll was wrong. Absolutely. And I think the correct position is a position that has been given by the High Court through Judge Mativo's reading. However, Betty, this is the problem, that I think what we fail to understand is that all this legalism, all this legality, all this constitutional talk surrounds a certain corpus of challenges that deal with the presidential election petition, presidential election. The presidential election is a political contest. You expect that it's going to be extremely emotive. It calls upon the players to invest heavily emotionally in terms of manpower, in terms of financial and other resources, and you don't expect it to be an easy task for either side. And so when you have something like that, the best route to take is to always look at what are the possibilities within the Constitution that can be used for purposes of resolving any dispute which arises within that particular contest. Okay? And it would really help if you get a consistent reading of the Constitution, not cherry picking, that, you know, this article of the Constitution supports my cause, so it is nice. Then the other article doesn't support my cause, or you read probably the article halfway, where, for instance, you just decide to read that this Constitution under Article 37 provides me with that right to picket and demonstrate. And then you don't read to the end, which means that you should picket unarmed and in a peaceful manner, while allowing the rest of the Kenyans to enjoy their rights, which are also guaranteed in the same Constitution. There are two important things that we must underscore. First and foremost, the electoral process in this country poses certain challenges to the existing system and the laws, but the electoral process in this country is not the only problem that we have as a nation. And it is true, yes, that we have several grievances coming out of various sections of this population which need to be addressed. But as I keep insisting, these grievances must be addressed within the general framework of the Constitution and the law. Because if you move out of this constitutional dispensation, then it means you are moving into a realm in which nobody will regulate the debate. It means you cannot parameterize the debate. It means you cannot effectively engage in a conversation as a nation. And today, as lawyers here, we are also Kenyans, and we also expect that this country will continue being here for us and future generations. And it behoves us, as we interpret this Constitution, to always put our country first and say, hey, we have seen many examples of people who have decided to go out of the constitutional order and try to look for solutions for political, economic, and other problems outside in the abstract, and the consequences have been dire. So for this country, can we re-engage? Can we soften our stances and agree, yes, this election is not going to solve all the problems that we have as a nation, but let's conduct it. That is the safer mode to be in as we get into a discussion on how to take this country forward. All right,
interesting. Great conversation we're having here in studio. But for now, I just want us to, all right. All right, I want us to cross over and speak to my colleague, Trix Ingado. We understand that there's a group of women which is at this moment marching to Uhuru Gardens to create awareness on the need for peace before, during, and after the repeat election. And like I mentioned, our reporter, Trix Ingado, is live there and just joins me. Trix, talk to me about which group of women is this one? Where do they come from? Is it from the civil society? Maybe you can just bring us up to speed with that.
Thank you, Betty. They call themselves, they are the White Ribbon Campaign. So women from various sectors, they are being represented by the NCIC, members from the sporting sector, members of the, NCIC, TJRC. They've come together from various sectors just to push home the matter of having the importance, having peace in the country, given the political situation that is ongoing. So right now, they are about to have a march across to all the way to Nyayo, just to have a peaceful march that's going to give us the importance, or pass the message of having importance, because we have a political situation right here, whereby nobody knows what's to take place. We know that what has been happening has not favored anyone in terms of the country going on with its normal business. So they say a lot of people have come out to speak about peace. A lot of people have come out to say there's need for peace. We have civil society, we've had the youth, we've had various people from different political sectors. But then they feel that maybe if they come out and speak about the importance of peace, maybe the country is going to listen. So with us now is a woman who needs no introduction, a veteran athlete, Tekla Lorupe, who's going to give us a few comments on why this is important. Karibu sana. Could you tell us, why is it important for women to come out and speak about the importance of peace in Kenya at this particular time in Kenyan history?
Thank you, my sister. I'm happy to be here.
I am an OLX champ. I can sell your car for you. You won't.
For me, as a peace ambassador, I see today it's really important for all the women to stand for their sons who have been shouting left and right. What we have here today is that women are calling themselves before 26. We are thinking of election, but what we can talk today is that women have to cry for code.
Oh, thank you very much. And maybe you could tell us, what are the plans that you are having today? I hear there's supposed to be a march. Could you tell us why you've organized this and how is this going to pass that message across?
I want to tell you, my sister, women all over the country, they are crying for this peace. And we cannot be here, all of us, but the few people that they have chosen themselves to come here, it to represent the cry for peace for this country. And also to ask our sons who are fighting one another because of political issue. At the end of the day, the women are the ones who are suffering. I want to tell you that I came from West Pokot, and we went to Lomut, whereby the market and Pokot, they don't sleep in their houses today. It's a painful. Who is sleeping outside is that woman. And that's why these women who are going to work today to demonstrate peace, we know that women are the last solution, because these are our matters.
Do you think that women will be more persuasive to the political players in the country? Will they have, maybe they might have an advantage over all the other people who have spoken about peace over and over again?
I want to tell you that many people speak about peace, and some they have their own agendas, but I don't think these women have agendas. Their agenda is to see that there will be no bloodshed in this country, that God will listen to their prayers, that He will choose one leader, and that leader God knows today. And all of us, we want to ask God to give us that favor.
And maybe to the political elite in this country, what would be your message? Because you've just mentioned that you've been on the ground and you have seen some women already afraid. They're not spending time in their homes because they are afraid for their safety. What would be your message to the leadership of this country?
My message to the political people is that to just leave Raila and Uhuru to talk alone. These are the sons of this country, and the other people who are just supporting them, probably they have their own interests, but if these people can sit down, they will come out and say, you know what, we want to have peace and we want to have a good election. If it's not on 26th, but God will choose a day that our country will celebrate for all of us. Let's support these two people. Let us not make them confused. My main message to our leaders is that I have not seen a leader who is standing there to talk about what's going on in this country. One gets up, talk bad about Raila. The other one gets up, talk bad about Uhuru. And I've not seen even Uhuru himself and Raila talking bad about each other. But the people who are surrounding them, that's my cry that my brothers, politicals, let's respect this country. When we see Sudan, when we see Somali, who want to be like them? And things are just a minute like this, and because of our tongue. But they should listen what our mothers are crying today. Me as an athlete ambassador, I just want to ask my security team that let's talk to our people. And also youths, let us not talk bad about others.
And last but not least, could you explain to us, in terms of when there's conflict, do you think women suffer more than the rest of the community?
My sister, as I told you, I just came from West Pokot, who was living outside with their children, are the women. And when the conflict comes, men run away because they are going to defend the country. A woman will lose food to feed their children, and she will lose their husband or their son. Who will suffer a lot? It's that woman. So I pray that the people should listen to our cry, because it's not our benefit, it's the benefit of them.
Okay, thank you very much. Very insightful comments right there from Tekla Rorupe, telling us that the women are the ones who suffer most in instances of conflicts, and calling for peace across the country. They're going to have a march all the way to Nyayo just to pass that message. The song they're singing right now is Kilio, a cry for peace in the country, and they're hoping that their message or their call might make a difference in the political situation right here in the country right now. Thank you very much. Betty, back to you in studio.
All right, Trix Ngado there reporting from Uhuru Gardens, and she's told you about that march by women just calling for peace and tranquility here in the country. All right, so one other story that we're focusing on is something that's happening in Mombasa. We understand that the court there is set to rule on an application by the Governor Hassan Joho on whether to strike out the petition that was filed by Hassan Omar that was challenging Governor Joho's re-election. It is being heard this morning before Justice Lydia Chode. Let's just cross over there for a bit and listen into what's happening.
Of 2013. In addressing the question as to whether the non-joinder is curable by amendment, Council cited the case of Amina Hassan that has been referred to earlier in support of submissions that the non-joinder of the Deputy County Governor cannot be cured by way of amendment to the petition. He argued that such an action would be tantamount to introducing causes of action not pleaded in the present petition. Council averred that causes of action herein are governed by Article 87 of the Constitution and Section 76(1) of the Elections Petition Act, which bar the introduction of causes of action after 28 days have lapsed. Mr. Nyamodi submitted that this is not a mere technicality which can be cured by Article 159(2) of the Constitution of Kenya, and he relied on the case of Kithinji Kiragu versus Martin Nyaga Wambora to support his submissions. The petitioner respondent's case, the petitioner in their submissions addressed, the petitioners in their submissions addressed the question whether the Deputy County Governor is a necessary party to the election petition and whether the non-joinder was fatal to the petition. Mr. Abubakar, learned counsel for the petitioners, submitted that the Deputy County Governor is a beneficiary of the Governor. He cited the case of Kithinji Kiragu, which has already been adverted to by Mr. Nyamodi, wherein the issue of non-compliance was raised in cross-examination. The court took the view that the proceedings concerned a validly elected party, and the Deputy County Governor is not such a validly elected party, but is a nominated party. Mr. Abubakar cited also the case of Dr. Thuoma Thenge versus Nderitu Gachagua, wherein the court held that the Constitution shall be interpreted in a manner that promoted the purposes of the Constitution. Article 87 of the Constitution intended the legislature to enact laws that would challenge elections. It was Council's submission that the Constitution shall be interpreted in a manner that promotes that rule of law, enhances human rights, as it's a human right to challenge elections. It was Council's submission that Article 181 and 182 of the Constitution are only triggered after the governor legally assumes office via a properly conducted elections. He argued that the rights of a deputy county governor only accrue when the person who nominated him is a successful candidate.